Thank you for joining us today. I'd like to welcome everyone to today's webinar, Everything You Need to Know About the California Consumer Protection Act of 2018. Before we get started, I want to go over some housekeeping items. This webinar is scheduled for 45 minutes plus 15 minutes of Q&A. We want this webinar to be interactive, so we encourage your participation. To participate, enter your questions into the Questions tab of the GoToWebinar console. And if we're unable to answer your question during today's webinar, we'll follow up by email. Lastly, I want to remind everyone that a recording of this webinar and a copy of the PowerPoint slides will be emailed to all registrants. So let's go ahead and get started. In this webinar, our guest presenters will discuss the California Consumer Privacy Act of 2018, which represents the most stringent state privacy regulation in the United States today. Billed as a California version of the EU GDPR, the CCPA includes GDPR-like requirements addressing the rights to access, delete, and transfer personal data. The law also includes rights not found in the GDPR, such as the right to obtain details about the sale of personal data to third parties, and the law is very complex. Potential fines could be severe. In this webinar, our presenters will review these new rights and offer perspective on meeting the compliance deadline. So at this time, I would like to introduce our presenters. Scott Giordano. Scott is a highly regarded data privacy attorney with over 20 years of experience, and he has recently joined Spirion in the last month as the Vice President of Data Protection, and he comes to us from Robert Half Legal. You may have seen some of the presentations he's done on our behalf over the last 3 years, so welcome, Scott.
Thanks, Doug. Great to be here.
And our co-presenter is Rob Server, Senior Solution Architect at Spirion. He has over 20 years of experience within IT and data security. So I'm going to go ahead and hand over the presentation to Scott and Rob.
Wonderful. Thank you, Doug. Here is our agenda. Thank you all for joining us. And I do want to reiterate that you have questions, send them in as we go through. We love taking questions as we go. So we're going to talk about this hour is a summary of the CCPA, which is probably a surprise to most of you, since it was a surprise to us in the legal profession as well. It developed almost overnight. So we'll talk briefly about how we got here, talk about who's protected, who's subject to it, so what are the principal requirements and other rights, how to comply with it. I'll offer some closing thoughts. So in a nutshell, CCPA recently brought into law effective January 1st, 2020, so about figure 17 months away, so about a year and 5 months, maybe a little bit less than that. So not very long at all. Think about GDPR, everyone had 24 months of runway. We have a lot less than that. This applies to consumers, and I'm using quotes there, as you can see, California residents. So if you're a California resident, then it applies to you. Unlike GDPR, however, if you're just visiting the state, it does not. So it's only for California residents. Rights, as Doug alluded to earlier, right to be informed about the personal data that's being collected by businesses about you, right to access and delete the information, right to prevent that data from being sold to third parties, which is an interesting contrast to GDPR, and a right to data portability, which is much like the GDPR. So the Act applies to all businesses that collect or use personal data in the United States, not just those in California. That's going to be a shock to a lot of companies. And there's some opportunities for some pretty substantial penalties when the California Attorney General prosecutes the action. There are other opportunities for private rights of action, but they're very limited. We'll discuss those towards the end.
Just a quick question, if you don't mind.
Sure.
So how does the CCPA treat cookies and third-party handling of cookies? These personal information elements, similar or the same as in the GDPR?
Yes, and in fact, in a couple slides, we'll talk about all the different categories. What's shocking about this regulation as well, and I don't use that word lightly, is that there's about 10, maybe 12 different areas of personal data. So you're all familiar on the call, presumably, with GDPR and all the different areas of personal data. This goes above and beyond that, including inferences about personal information, not just the personal information itself. It's truly shocking. It's a heavy lift. And so, yes, cookies are definitely part of that, IP addresses, all the usual suspects.
Great, thanks. And I'll launch these questions at you as the participants present them.
That's great. Fire away. So who does it protect? As I mentioned earlier, it protects consumers to California residents. So unfortunately, if you lived in California for much of your life but left and you're no longer a resident, it does not apply to you, which is interesting because I lived there for many, many years, but that would not apply to me. So it's only current residents. And it essentially covers any for-profit entity. So that includes healthcare organizations that are not covered by HIPAA. So if you're a pharmaceutical company, for example, or a clinical research company, well, you're covered by it. It covers for-profit schools, covers students, for-profit schools, etc. And we'll talk a little bit more about that as we go. It talks about devices. So it's not just consumers that are covered, it's also devices. So think about anything connected to the internet, your cell phone, routers, etc., etc. Any Internet of Things, IoT-style device, that's covered. Households are covered, although they're not defined in the law, but they are covered. So say that you're an electric utility and you have information about different households, however many households in your service area, that kind of information is covered. So that's who's protected. Let's go to the next slide and we'll talk a bit about the businesses, because this is where things get a little shaky. So 3 types of businesses, presuming you're doing business at all in California. 3 different criteria, and they're mutually exclusive. So if you have one, you don't have to have the other. So for example, if you have annual gross revenue in excess of 25 million, or if you buy, receive, sell, or share commercial personal information for commercial purposes of more than 50,000 consumers, households, or device. So it could be 30,000 of one and 20,000 of another, or any permutation of that, then you are subject to this. Or if you derive 50% or more of your annual revenue from selling consumers' personal information, then you're subject to this. And think about all of the app vendors and all of the startups and what have you that really make all their money from selling personal information for folks in exchange for the access to the application. You can see how many organizations and companies are going to be subject to this. So a lot of businesses in the U.S. are going to be subject. It's not just those in California. It's a big deal.
Scott,
Yeah.
a few questions that
Sure.
related to this topic, but does it apply to government agencies? Here's some other example, pension plans, or is it limited to public, non-public companies?
It is limited only to for-profit legal entities. That's it. So it won't cover government agencies. As far as government-sponsored organizations or enterprises, GSEs, it's a good question. I don't know. That's one of those things that I'll review and we'll answer when we do the next webinar, because we'll have a lot of questions from this. Generally speaking, any for-profit entity is going to be subject to this, and that pretty much excludes everything by the government, again, with some examples for GSEs. What's interesting, too, is it covers sole props. It's not just corporations. You could be a partnership, you could be a sole prop, an LLC, anything. If it's for-profit, then typically you're subject to it.
Great, thank you.
Let's head on over to the next slide. These are, in a nutshell, the principal requirements of the consumer rights, depending on how you define them. There's a massive amount of substance to this law. This really, even though it's only 20 pages long, it's very dense, and you're going to find that it compares favorably in terms of scope of complexity to GDPR. I'm just going to touch upon the big ones right now because we could spend an entire day and we'll probably have a lot more seminars just on this because it's so complex. But in a nutshell, you're going to have to publish notice of your privacy practices, which I'm sure all of you on the call are already well versed with. So you're going to have to add a lot to that. Offer people a right to access and delete personal information, a la GDPR. So if you're a GDPR fan, you're going to love this. Right to be informed of personal data that's sold or disclosed. This is new. We'll dig down into that. Right to opt out of that same sale. Right to data portability. So if you're familiar with GDPR's data portability, same exact idea. Requirement to opt in for children under 16, but there's some contingencies with that we'll talk about. So let's take a deep dive into privacy practices. This is the idea of publishing this presumably on your website. So if we go to the next slide, the way the law is structured is they tend to cross-reference and circular reference itself a lot. There's a little bit of redundancy here. So just for the sake of our webinar here, 3 areas in general. You have to disclose the kind of personal information you collect in general about consumers. You have to disclose if you're selling or transferring that data. And you have to disclose that you can't discriminate against people because they exercise their rights, which sounds nice. No one wants discrimination, but they don't really define discrimination. It's a bit of a puzzle as to what qualifies for that. Also, you have to put a method for making that request on your website or put a toll-free number or something of that nature so that you can exercise your right to disclose. And then with respect to specific information, if we go to the next slide, we'll drill down another layer here, and you'll see that there's 5 different categories. Personal information that you've collected in the last 12 months about the consumer, where you got it from, the commercial purposes you used it for, which third parties got it, and a typo or a bug, if you will, the specific pieces of personal information that you've collected about that consumer. You don't really have to, that would be ridiculous. You wouldn't really publish on your website information about individual consumers. That was just a copy and paste error. So I wanted to highlight that. Also on Eric Goldman's site at Santa Clara University, he's got an entire list of all the bugs and errors and strange things that have shown up in this statute. So if you really want to take a deep dive, highly recommend going to his website, and you'll see all of the various bugs and copy and paste errors that are in here. And then thirdly, list of categories of personal information that you've sold or disclosed in the last 12 months. Or if you don't do that, then note that as well. That's the 30,000-foot view of your notice of privacy practices. So I imagine most everyone on this call already has a website that has a privacy statement or notice or policy, whatever you want to call it, that you've updated perhaps for GDPR, or maybe you did a separate one for GDPR. I worked on GDPR projects for almost 2 years, and there was innumerable ways to go about that. Some put their own website that's separate for GDPR, but the net of it is that you're probably all well versed with that.
A couple of questions. Could you repeat the reference cited?
Professor Eric Goldman at Santa Clara University, he's got a website or a blog, I think is a better way to say it, and done a great job. So have others, by the way. I'm just going to call him out. Eric Goldman, Santa Clara University, just go to his blog and he'll list almost ad nauseum how many drafting bugs and inconsistencies there were in this thing. Because remember, this law was banged out in about 36 hours, which is probably a record for the California legislature. And it was done so because there was an initiative petition that was going through and getting ready to go get posted for being voted on in the fall. And so in exchange for dropping that, the California legislature was allowed to throw this together and get it passed. And I emphasize they threw it together. So you're going to find a lot of drafting errors here that allegedly will get fixed at some point in the future.
Great, thank you. A question for clarification.
Sure.
Does the CCPA also allow you to prevent the transfer to a third party if there is no consideration paid?
Oh, good question. It's undetermined at this point. So say that for some reason that you just want to just disclose it or transfer it without any benefit. I think that would violate the spirit of the law. And so my guess is the answer would be no. Now, you may say, well, wait a minute, doesn't that, what about nonprofits and so forth? Remember that this applies to for-profit organizations. So presumably nonprofits would still get essentially an exemption for this if that's what the scope of the question is. So I think the net is, even if there was no consideration, transferring that data is unfair, if you will, because you didn't get an opportunity to opt out. So I think that would still not be acceptable.
So a couple interesting differences, Scott, as you're talking about opt-outs. Does this mean the default behavior for this law is to allow companies to allow opt-in where the person has to opt out of a particular?
It's interesting you mention that because in GDPR, it's all opt-in. Basically, you have to give consent. Here, you have to give everyone an opportunity to opt out. So in theory, and put aside children for a moment, in theory, everything is opt out, but you have to give everyone that opportunity to opt out. And you have to put that up on your website. And you have to put a link that we'll talk about in a minute that says, literally on your website that says, do not sell my personal information. That's what you have to put on there. So the net of it is it's an opt out vis-a-vis GDPR, but it's a pretty blatant click here to opt out, if you will.
Okay, so yeah, that's another difference with GDPR is that it must be presented in plain language. I don't see that here either. So that's an interesting point. The next question I have is...
So a few more questions, Scott. Is there something similar to the Working Party 29, which is part of the EU member state? Is there?
There is not. I wish there were, and maybe now is the time to do this. For the benefit of the audience, the Article 29 Working Party, which is now called the European Data Protection Board, is a EU-wide think tank with respect to the European GDPR. And so really all of their opinions, even though they're not legally binding, are very highly regarded by the data protection authorities and the supervisory authorities in the courts. Do we have such a think tank here in the U.S.? No. Do we need one? Yes, absolutely. We're long overdue. So hopefully we will see that happen. So right to access personal information. So those of you that are familiar with the EU right to request or data subject access request, or DSAR as we call it, essentially the same thing. You can request the categories of information and that have been collected about you, and I'll give you those specifics in a bit. Sources that you got them from, the business purposes that's being used for, and third parties that are getting this, which is great. So you can get a list of all the third parties, and then the very specific piece of information about, so within 45 days, they have to give that. If they're having issues or they need to have more time, they can get another 45 days. Generally speaking, the default is going to be 45 days. For GDPR, it's 30 days, plus you can get another 30 days, so this is a little bit longer in that respect. So right to delete. So if you have information that's been collected and you want to delete it, you can have it deleted. So this is very similar to right to erasure that we have in GDPR. Now, are there exceptions to it? Yes, there's some exceptions. I'm just going to run through it super quick because I know someone will probably ask, hey, can I get my grades erased from that for-profit college I went to if I didn't like my grades? The answer is no, and I'll show you why. So the next slide, you'll see that one of the exceptions is to maintain a contractual relationship. In fact, that's item 1 here, contractual relationship with the consumer. Presumably, part of that contract is not erasing student records or making student records available from now until you die, basically. Effectively, that's going to be an exception that a for-profit university would invoke. And there are other ones as well here, as you can see. I'm not going to drill through these because they're not going to be relevant very often, but they are here. So right information, personal information, sold or disclosed, this is different from how things are done. GDPR doesn't have a functional equivalent of this. So you've got a right to be informed by a business of the categories of information that is being collected about you and what's being sold and to whom it's being sold and what's being sold. And so, and business purpose for what's being sold. So essentially, this is another requirement, if you will, to be able to notify upon request someone that their personal information is being sold. And then it gives you the opportunity to opt out. If you go to the next slide, we'll talk about opt out. And so you get to opt out. So what you have at the right of any time is to tell a business that's selling its information to third parties not to sell it. And if the business is selling it, they have to give the third party the opportunity, give you the opportunity to opt out and give the third party the mandate to not use that information. And then you can't sell it unless the business has given explicit notice and the consumers have the opportunity to opt out. So again, you're seeing a lot of this seems very duplicative. And you'll find that that's just because of the speedy nature of how the law was drafted. You're seeing a lot of the same requirements that are multiplied across the statute. So if you see that and you wonder, gee, why it just said that here and now it says it again, you're going to find that that's the case in many parts of the statute. There's about 10,000 words here, and there's a lot of duplication. So that's why you're seeing a lot of things here.
Any opinion as to why the California legislature didn't make opted out the default, have the consumers select opt-in if they want to, similar to the GDPR?
I think because, think about how many tech companies are headquartered in California, and if you had to opt in for everything, that would basically just cut off all of their revenue because most people are not going to go out of their way to opt in. So I think that's the reason why they chose that model, because otherwise they would have probably had a lot of unhappy corporations, especially in Silicon Valley, but really statewide, that would have said, hey, you just cut off our revenue. So I think that's the reason that was the driver for that. So data portability, I'm just going to touch upon this briefly. Think about GDPR, they have the same data portability, right? Essentially what's happening right now is that Google and Facebook and a couple other companies are working on a data portability standard. So presumably you can download that data and move it to another platform or at least upload some portions to their platform. So that is going underway as we speak. That's just those vendors, but presumably all companies will eventually engage in a platform portability mechanism of some type. But this is going to be very beneficial to consumers. Think about how many times perhaps you've applied for a job and you have to fill out the same information on every single site using, always the same system. Presumably, if it's all portable, you can just upload that to every site and not have to spend a day banging out a job application. So it's got a lot of potential for consumers. A requirement to opt in for children under 16. Essentially, if the personal information in question is for a minor under 16, then you have to get permission from the minor. If they are between 13 and 16, if they're under 13, then a parent or guardian has to give the okay. If they're 13 exactly, We don't know because of a drafting error here. It's unclear what happens if you're exacting 13. So I imagine that'll get fixed in subsequent legislation. So we'll go to the next slide. There we go. Secondary rights. This is interesting. One of the rights, and I'm using air quotes here, is the right to no discrimination. So you, for example, cannot, if you invoke these rights, don't sell my personal information, in principle, the business can't charge a different price or a different rate for the service they're doing and can't give you a different quality of service. So, but here's the problem with that is suppose that you're a business and you depend on selling, you give away free software, you depend on selling personal information, and anonymizing it's not enough. Okay, it seems to me that that's going to be a problem because you can't do that anymore because you're giving a different level of quality or service for that piece of software. However, then if you look towards the bottom, item 2 or sub 2, it says that it's okay to charge a different rate if you're offering a different level of quality or service to the consumer. So the two seem very contradictory. Also, it says that if that difference is reasonably related to the value provided to the consumer by the consumer's data, I think they meant to the business. So again, I think that's a drafting error that'll get fixed down the road. So the net of it is that if you operate on one of these freemium models where you're giving away software, but you're processing people's personal information, unless you're anonymizing it and aggregating it, that kind of a thing, de-identifying it, it's going to call into question whether you can even offer that anymore. So it's a question mark at this point, but it's something for all of those of you that are doing startups or in the tech business, it's something to keep your eye on. Okay, let's go to the next slide. So other aspects, we'll talk about what's personal, what's not personal information. There's exceptions to this, and then we'll talk about potential sanctions. So let's go to the next slide, Doug. Personal information. This is what's really shocking about this, is you may think, okay, it's going to be the same stuff that I've always dealt with. It's going to be IP address, email address, social security number, driver's license number, and that's true. Those are things that are easy recognizable and things that are relatively easy to find. So that's great, but wait, there's more. If we go to the next slide, there's about 10 to 12 categories of personal data. So now you have another category here. So you have here name, signature, again, SSN, but also physical characteristics, address, phone number, passport, employment history, bank account, the list goes on and on and on. So now you have also medical information, okay, health insurance information, so a fairly large list. And you may think, okay, great, we're done here. But wait, there's yet more. So if we go to the next slide, there are more categories of personal data. Now, characteristics of protected classifications under California law. What they mean is protected classes. So racial, ethnic, religious, et cetera, et cetera. Commercial information. So your records of purchasing a history. So maybe you spend time on Amazon or eBay, all of that, all those records, that is something that's now personal data. So it goes on and on. Biometric, not terribly surprising. Internet activity, we talked earlier, someone asked earlier about cookies and browsing and all that. All of that's the case. Geolocation data, so your GPS coordinates, that's personal data. And yes, but wait, there's even more than that. Audio, electronic information, olfactory. I liked how they snuck that in there. So smell information. Presumably the smell information that's been recorded electronically. Otherwise, I don't know how you would protect it. But that's personal information. Professional or employment. So think about your resume, your CV. You probably get your resume everywhere on former companies you've worked for or on job sites. That's all protected information. Your education information is also personal information. Inferences, and this is really amazing. So it's not just the personal data, it's inferences drawn about personal data. And you think about how that endless, the different scenarios, and this is one of the things in GDPR compliance we struggled with, about how far down the road you have to go. It's implicitly inferences are something that you have to think about. Here, they're explicit. And so this is going to be a lot of work. It really is. It's amazing. So you have about 10-ish categories, depending how you slice it, of personal data, much broader even than GDPR, and that was pretty ambitious.
A lot of comments, surprised, wow, quite a long list. Is there a volume issue, and how should an organization go about tackling aggregating data or wrangling all this information? I just want to note to the participants that we're getting a lot of questions about consent, opt-in, who's included and excluded. We'll address those at the end of the presentation. Is there a volume size issue?
It's going to be a huge volume issue in terms of just collecting the data. So yes, if you think about it, these are all individual areas now that, as an organization, you're going to have to go through and do that data inventory. And all of those of you who've already suffered through a data inventory, guess what? You're going to be doing it again. And if you have not suffered through it, you will get that opportunity now, because you have to think about it. And I'll use a great example. Say that you're on one of those companies that does house calls for whatever reason. You're doing electronics, you're fixing laptops or what have you. Now you're walking to someone's house and you're seeing all kinds of personal information. As a consequence, you can be making all kinds of inferences. I mean, the list goes on and on about how many considerations you have to have. It's not just for electronic information, it's what you could do with it potentially. So that's going to necessitate going through a data inventory and thinking, how could this be abused? How could this be misused? That's essentially the core of when we did the data protection impact assessment. That's the question I was asked, is how could this be abused or misused? Same situation here, just even broader in its scope. In terms of de-identifying data and aggregating it, I know for medical data, there's a set of standards that you have to use for removing identifiers. I think it's 17 or 18 different fields have to be removed. I think there will be standards coming out that we publish just to address that topic. We may have to borrow from GDPR and the Article 29 European Data Protection Board folks. We may have folks here that are going to produce something, but you'll see some kind of standard come out to de-identify data, because now it's essentially part of our national privacy protection, if you will.
So participant comments that all data concerning consumers, employees, and patients will now need to be meta tagged, period.
Yes, and it's funny because it's easy to say, oh, well, if it's patient data, it's covered by HIPAA, that's exempt. That's true, but keep in mind that you could have patient data that was quote unquote de-identified and then sold to a research organization. And the question is, great, is it truly de-identified? Did it use all the standards that were required by either NIST or whoever? And if not, then essentially you've got now data that's outside of HIPAA, but still has to be protected by CCPA. So it's very easy to think you're in the clear when maybe you're not. So it necessitates a lot more work to make sure that you've done that aggregation or de-identification, because there's, as I said earlier, there's no standard. So you have to use essentially best practices. And so you'll see an entire industry now arise just to develop those standards. Okay, let's head over to the next slide. So we'll talk about what's not personal information. Here we have a bit of a bug. We know that what's personal information, but what's not is, one, there's a bit of a bug in the law here. So if you look at where I've highlighted in red, where it says publicly available information is not personal information. Okay, that's fair enough. For these purposes, publicly available means information that's lawfully made available from federal, state, or local governments. If any conditions associated with such information, blank. So they left something off at the end. It may be, we don't know what they left off. So that's a bug that's probably going to get fixed in subsequent legislation. Also, another bug here potentially, where it says at the bottom, publicly available does not include consumer information that's de-identified or aggregate. I think what they meant is personal information does not include consumer information. So again, a lot of this, if you go to Eric Goldman's blog, he goes into great detail about some of these inconsistencies. I'm pointing out a couple, but if you really are curious about this, you'll find that there's quite a few. So net of it is that if it's publicly available, it's not personal information. Not terribly surprising, but really things that are publicly available state, federal government records. So let's
Question. Can a potential federal law preempt or supersede the CCPA?
Absolutely, and in fact, many of them do, and that's one or two slides down the road, but the short answer is that yes. For example, if there's a conflict with Fair Credit Reporting Act, conflict with FERPA, for example, or just a conflict with a federal law that preempts state law in that area, then the answer is absolutely yes. Funny they asked that, so exceptions to the act. If you have to comply with a federal, state, or local law, address subpoenas, court actions, etc., or if it is de-identified, I mentioned that a couple times here, or aggregated, or if the action takes place entirely outside of California, then presumably California doesn't have interest in it and it's outside the act. That preemption we talked about earlier, that's where it's cited. So if we talked about PHI, so if it's covered by HIPAA or by the California version of that, which is the Confidentiality of Medical Information Act, that's not covered. If it conflicts with FCRA or GLBA, then to the extent it conflicts, then it's preempted by federal law. Generally speaking, if there's any conflicts with federal law, this is going to lose. Sanctions. So two species of sanctions here, and this is a really curious situation. So what you have is if you have a breach, what you have to do is you have a requirement. If there's a breach, you have to give the company that did the breach or suffered the breach an opportunity to cure the breach. Now, I'm using air quotes here, you can't all see, but they get an opportunity to cure. Now, you may say, well, what does cure the breach mean? It's a great question. It's not defined. And really, when you think about it, if you've lost someone's personal data, it's out there on the internet, I don't know how you cure it. I don't know how you unring the bell. So you have to give organizations an opportunity to cure it. That's a great question of how that's going to be effectuated. But if they don't cure it, then the AG's office can go after them. They can go after them for willful violations up to $7,500 per incident. And so now, does that mean per record, per breach? Presumably it means per record. If it was per breach, it wouldn't be very, very stringent. But if it's per record, then it's going to be potentially astronomical. The net of it is that if the AG goes after, it can be really big. If it is an unintentional violation and the company does not cure it, then it's up to $2,500 per violation, again, presumably per record. Otherwise, it wouldn't have much teeth to it. For regular folks, there's a very limited right of action. If we go to the next slide, Doug. So if you're a breach victim, you can have and this is just limited to breach, it's not for any other violation. If there's a breach, you can, if they don't cure, if the company that suffered the breach doesn't cure it, however that is done, then you can bring a class action lawsuit between 700 to 750 at a minimum, or actual damages, whatever is higher. So you can also ask for injunctions and things of that nature. The question is, also the AG's office can preempt that though. So they have to be given an opportunity to jump in and take the lawsuit over, essentially. So the net of it is that I don't know how many breaches are going to wind up being punished under this law, at least by class action lawsuits. And I imagine that was another motivation for the California legislature to get this done so fast, because otherwise then it would have been a huge opportunity for tort lawyers to bring class action lawsuits. So as a consequence, that's one of the reasons that this is so tightly circumscribed and limited just to the Attorney General's office. So the net of it is that if the AG comes after you, you can expect pretty severe fines. If it's a breach and it's a class action lawsuit, potentially less so, depending on whether the AG will take over the lawsuit or not. If we go to the next slide, just some questions to be resolved. There's lots and lots and lots of questions that need to be resolved. So what's in a name? Right now, you may ask, what is this just for a subsidiary? If a subsidiary of a company is responsible for this, they have the 25 million in sales or what have you, or is it go to the parent company or another company that's co-owned by the parent company? The answer is we don't know. We know that if you have a common brand, so if the parent company has brand ABC and a subsidiary has brand ABC, then they're considered to be one unit for purposes of this. And therefore, you aggregate all their activities to see if they're subject to the regulation. Problem is, suppose that there's a slight variation on the brand name. Is that the same thing? We don't know. So what's in a name? There's quite a lot, in fact. Also for thresholds, this is another issue too, is that do you need 25 million in sales inside California, or is it just collectively? So you have 25 million in sales just as a company. If the latter, then pretty much just every company in the country is potentially subject to this just about, because 25 million is a pretty low threshold. Or 50,000 consumers, households, or devices. Well, suppose that you've got way more than that nationwide, but you have some folks in California. Does that count? Or does it have to be a minimum of 50,000 in California? We don't know. And so in terms of sales, is that, again, California, US, global? We don't know. So that has to be resolved. What's a household? We don't know. They haven't defined it. Are the households supposedly just in California? Could they be elsewhere? We don't know. What is reasonable security procedure and practice? No standards are defined. And there's no reference to something like, say, ISO 27K or just anything. There's just nothing there. So we don't know. It could be the judge simply is going to look at some standard that is generally accepted in the relevant community. Don't know at this point. So a lot of questions to be resolved. Hopefully they'll be resolved by future legislation in the next 17 months, but there's no guarantee of that.
Sure, Scott. Then the question I wanted to ask earlier, it's summarized on this page as well, is the absence of, appears to be a retention period for data like you see in GDPR, where you're required to report to the subject how long the data is going to be held for and have an exit plan for getting rid of that held data. That does not appear to be here in this case.
No, it doesn't. What's interesting about this is this applies to information collected in the last 12 months. Presumably, anything older than that, you can delete, assuming there's no other laws that require you to keep the data. So it's just that data in the last 12 months that's applicable. So you don't have to tell someone how long you're planning on keeping it, or whether you should, when you're going to delete it or how you're going to delete it. If it's required to be deleted, presumably you'll want to put together a certificate of deletion, but that's not required here. It just says just delete it. So really, as a practical matter, just 12 months of data and that's it. So it doesn't seem particularly helpful, but that's the limit they set for this. So how to comply? A couple things. One is data inventory, and I've spoken about this at length throughout the presentation here tonight. I did because this really is going to require, as an organization, going through and looking at all the places that you process personal data, as you did in GDPR, and go through, identify the personal data elements, get an idea of with whom you're sharing it, and then create a mechanism to give people opportunity to opt out if indeed you're sharing it or selling it or disclosing it to third parties. So this, of course, then begs the question about working with your third parties, because now they have to comply, and they may be entirely outside of California. They could be outside of the country, for that matter. So that's going to create another list of duties for you above and beyond the inventory, is working with those third parties that you're sharing the data with. And most companies share data with third parties, even if it's with someone storing the data. So that's going to be a job in and of itself. Consumer Information Access Request. I don't know what they're going to call these. I'm just calling them CIRs, Consumer Information Access Request, as opposed to DSARs. You're going to have to authenticate this so that someone doesn't pose as someone else and grabbing their personal data. You're going to find a way to collect and package it, and it's got to be in a portable and useful form, as we mentioned earlier, and you got to do it within 45 days. That's a huge, huge task. In fact, when I worked on GDPR projects, I found that probably 1/3 of the work was just putting together those mechanisms to validate and verify people, and then be able to package the data up for them. So, because most organizations have not had to do that, and so now that's a new skill they had to develop. So another 1/3 was data inventory, and then 1/3 was everything. Finally, opt-out, opt-in mechanism. A lot of times in GDPR terms, we call this consent management. So there are consent management tools out there, but if you want to build your own, certainly you can. But you have to create a mechanism that allows people to easily opt out and opt in, and presumably push those out to your third parties. Again, you'll be working a lot with your third parties to be able to address these things. So it's going to be a big challenge, needless to say.
I saw something else interesting, Scott, that while I was looking through the regulation, it states that the organizations are not required to supply information for a request, a subject access request, more often than once every 12 months.
That's true. And it's not unlike credit reports, where you can get a free credit report every year, et cetera. Otherwise, you have to pay for them. Similar kind of idea here. So really, it's in some ways limits the utility of being able to get your data subject access and see what people are processing, but that's the limitation that's baked into this. So it gives you a yearly snapshot, essentially, of what your personal data is, and gives you the opportunity to correct and delete it, and also opt out. So again, it's not exactly tracking the GDPR, and in fact, in a future webinar, we'll do a side-by-side to talk about the differences between the two.
Scott, see if we could stump the attorney. So do you think section 1798.81.5 will be updated with a better definition of reasonable security?
Boy, yeah, I am stumped, and I'll say why. Because there should have been a definition a long time ago. Because you think about it, you can grab your definition from just about anything. You could go to a internationally respected standard like ISO 27K, which is a very high bar. You can go to CSC Top 20. There's so many different ways of doing it, and there's so many different published ones. But they should have cited something, because otherwise now it's going to be a case-by-case scenario as to what qualifies as reasonable under the circumstances. Now, you can argue that GDPR didn't publish a standard either. They just said it's reasonable according to the risk involved. And again, that's great, but it's not a lot to hang your hat on. I mean, you have to essentially take a risk that the standard you're looking at is going to be good enough. So in answer to the question, I hope so. I hope they refer to a standard. Any standard will do, just let's have one.
So the same person who asked the question says the Attorney General made recommendations to use the CIS 20 CSEs back in 2016. Any comment? If
they did make that recommendation, then it's going to be hard to argue that that's a bad way to go. And I like the CSC Top 20. I've been involved with it for a couple of years now. I remember way back when it was the SANS Top 20. It's a great set of controls. So if that's something you're already keen on using, I'd say go for it. Certainly, you can make arguments that there are other standards that are equally good, but if the AG has opined favorably, I'll have to pull up if it's an AG opinion or it's something else. That's also going to make a determination. If it's a true AG opinion, then you've got something to work with, and that's something you would cite in a brief if you were defending yourself in court. Other questions, other comments?
There are a lot of questions about opt-in, opt-out, but I'll save those for the Q&A session.
Okay. So I think we are almost done. Let's go to the next slide, Doug. I think we've just about, I just have to do my final thoughts. So one more and then I'll do my final thoughts and we'll go to Q&A. So how to comply, again, address verification for children. There's the whole idea of opt-in, opt-out. A subset of that is verifying children to make sure that, if truly they're California residents, then that's something that's going to have to be addressed. You're going to have to update your privacy statement on your website, a la the privacy policy. You're going to have a link to it that says, do not sell my personal information. Like quite literally, that's what's being prescribed in the law. Put that link that says those words. That way you can get to the opt-in, opt-out. Review your incident response and your breach notification procedures, because that's all the more critical now to be able to show that you've quote unquote cured something. Again, I don't know how, but to be able to update those procedures and say that they're consistent with what's generally accepted is a great way to go. And then finally, address your data portability. I have a reference in the white paper that we're going to be issuing on this subject to the data portability projects that are going on right now. So I'll cite to that so that you guys can take a look at that. And I think that that's it on how to comply. I have some final thoughts, and then we'll go right to Q&A because I'm sure we've got a bazillion here. This is truly the most demanding privacy at the state level that we have in the U.S. It is not unlike GDPR in many ways. Some ways it's different, like no selling of personal information without permission. Guidance is going to be needed in all kinds of areas. Penalties are going to be severe because the AG is definitely going to use this as an opportunity to make examples out of organizations. You can bet this is going to be the first of a wave of state privacy regulations. And I know we have an upcoming webinar on state privacy regulation updates. And so you're going to see states now follow California, much like they did back in 2002 when California came out with the first breach notification statute. Now, I think all 50 states now have them. And so we'll see the same thing almost certainly with this statute. So the net of it is get started with your data inventory. Don't assume legislation is going to come to the rescue, because this is extraordinarily political. They'll fix some things that are drafting errors, but I would not expect any substantive changes between now and the time that it goes live. That's it. I am ready for the Q&A, for the lightning round, as it were.
Great. I'll just start launching questions at you. How does this compare with the upcoming Colorado privacy law in September?
You have successfully stumped the attorney. I have not done a side-by-side. So when we do the state attorney or state privacy update, we'll do a side-by-side for all the states that are relevant. My guess is, though, is that whatever happened in Colorado is not going to be nearly as stringent as what's happening here. So that's my guess. I think it'll be proven out, though, when I do the research.
Interesting. Do you think there will be federal law that will be similar?
Oh, boy. That's a great question. Supposedly, there is a lot of discussion at the federal level. The problem is getting anyone to agree at anything at the federal level is very difficult. And you think about it, nothing's going to be done before the election. After the election, it may be the dynamic has changed so much that there's just not going to be any agreement. So I wouldn't count on the federal government adding to this. And the idea that they're going to somehow preempt state law, I don't see it happening. That would create a lot of hostility. So the answer is, I think, no.
Great. Next question. How will the state enforce this? For example, with, GLBA, the regulators acted as an enforcement mechanism.
The net of it is we don't know. And here's why. How do you know if a company has 50,000 customers? Or how do you know how much money they're making, especially if they're not publicly traded? You really don't know if they're in scope. So a lot of this is going to rely on individuals complaining to the AG's office and saying that my data is being abused. So that's typically how it's going to be enforced. It's going to be by exception, unless the state is going to start surfing websites and looking for companies that are doing business in California and looking at their privacy statements. I think almost entirely they're going to rely on complaint, like they do for a lot of everything. It makes it difficult for compliance in that respect.
Great, thanks. Now I'm going to start launching the consent questions.
Sure.
Is explicit consent allowed, especially for health-related studies or research?
Is explicit consent allowed? Explicit consent is almost always allowed for just about any privacy regulation. If you obtain explicit consent, pretty much you're covered. Really what the challenge is when someone has no idea their personal data is being sold, then there's where you have an issue with violation. But if you get explicit consent up front, especially for medical research or medically related anything, typically you're just fine, as long as that's being passed on to the next link in the chain. If it's a research institution, for example, they have a copy of that. And if they're not exceeding whatever you've agreed to, that's another issue. Same thing with GDPR, is that if you're changing the purposes for which you're using the data, you have to go back and get updated consent, unless you've made the consent so broad that it covers everything. But even that could be suspect.
Great. Next question. If you're using a web-based SaaS solution to provide email marketing to your customers, is this considered a disclosure of PII that you need to share?
Likely. And here's why. Because if you're selling that data, or you're disclosing it or sharing it with another party, then potentially the same issue is even not getting money for it, even if you're getting something in kind, or you're disclosing it as part of a larger commercial operation. If you're selling email addresses, then you're captured by this. And so you're going to have an opportunity for people to opt out as a consequence. And we'll have a webinar just on ad tech and marketing and all of that, because that's its own subject. But the net of it is you're going to have to give people an opportunity to opt out of that. Great.
Continuing down the line of opt-outs and consent, how would an organization handle chat information between a California consumer and, say, a customer service call center about health-related information, for example?
Well, in terms of giving them a chance to opt out, or what's the context?
I believe it was consent.
Oh, for consent. So there's chat information going back and forth on a customer service line or something like that, or a tech support or something that's involving health information. In terms of getting permission, remember, if they're not selling the data, okay, then there's no opt-out issue. So typically, you're not going to be selling someone's, presumably their medical information, without consent anyway. So I don't think it's going to be much of an issue. If there's a concern about deleting that chat session, and that's something that came up for GDPR, by the way, then essentially you're going to have to find a way to isolate that information and simply delete it after the end of the call. If the person, for whatever reason, asks to have that deleted, you may also create a checkbox that says delete my information once we close this window, or something like that, assuming there's no law that requires you to keep it for accounting purposes, or for some law, like, for example, SEC information, have to keep it for 7 years. Assuming there's nothing that's countervailing that, then presumably you put a checkbox on the chat window that says delete my information when we're done. That's how I'd go about it. I'm sure there's probably better ways.
Got it. There are probably at least another 20 questions related to consent and opt-out. We'll reply, Scott, we'll ask if you replied to those via email. But I thought this is a really interesting question, probably worth the last 3 minutes, and maybe even possibly a blog post. But can you discuss industry opposition and what political action committees or PACs did exactly on behalf of particular players? And this participant quotes that they were non-committal. McTaggart said, but in February, Facebook joined Google, Comcast, Verizon, and AT&T to contribute more than $1 million to a PAC to set up and oppose the measure. Any comments?
Well, I mean, you think about it, that in any situation, your business model is going to be disrupted. You're going to have opposition to it. And I think that had this law not got passed and this went as a ballot measure, which is what he's alluding to, the caller is alluding to, is that then they would have had to try and defeat this at the polls. And Californians, for whatever reason, typically vote yes on everything. And certainly this is a no-lose for Californians, because you're going to say, yes, protect my personal data. And that would have been set in stone. So I think that the net of it is that this is going to disrupt business models of Silicon Valley companies in general. And I think that's why they opposed it. And I'm not surprised they opposed it. There was a lot of opposition to GDPR. So, and I'm not taking a stance on whether it's good, bad, or otherwise. It's just that's the nature of personal data nowadays, because we've become so used to selling it as a nation. It's a big change. So I think just to put a period on that we'll see more political opposition to this, and we'll see pressure on the legislature to make changes. The problem is that if they make significant changes, the person that sponsors this will just bring it back, and it'll be potentially even more stringent. So there's a lot to be unraveled between now and January 1st, 2020.
Great, thanks. In the last minute, I'd like to just wrap this up. Thank you, Scott, Rob, for your contribution. We got a lot of great comments, feedback on commenting on the highly detailed webinar. So we'll continue on this series over the next 17 months. Every month, if not every month, we'll be touching on the CCPA and possibly other state regulations or federal regulations that pop up and evolve. Our next webinar I want to invite everybody to, and we'll send out a link after the webinar, is on August 22nd. Scott's going to talk about the top 10 challenges of the CCPA and how to overcome them. And lastly, I just want to remind everybody what Spirion does is, for the CCPA, one of the very first steps we believe is inventorying your data and understanding where your customers or consumer data lies across your network, whether in structured or unstructured environments. And what Spirion does is we accurately discover sensitive data, classify it, so you can remediate it or reduce your footprint and monitor all that sensitive data. So we invite you to join our next webinar or visit our website. And if you have any questions or would like to start a dialogue with Scott, go to our website, visit the Contact Us form, type in your questions. We'll get back to you immediately. Again, thank you very much for joining us today. And thanks again, Scott and Rob, for your time. It's a great webinar. So that concludes today's webinar. Thanks. Have a great day.